Well, good afternoon, ladies and gentlemen. My name is Gerard Hogan, and it's a great honour to have been invited by the Chief Justice to participate in the Hardiman Lecture Series. And before I go any further, I would like to extend my very sincere thanks to, in Dublin, Rachel O'Byrne for organising this, and in Luxembourg, my assistant, Cian Kinsella, who has been quite wonderful in organising the slideshow, which will be really the feature of this particular lecture, I hope. Now, just before we go to the slideshow, just a word or two of explanation as to what this lecture is all about. It's about four favourite judges of mine, Oliver Wendell Holmes, John Harlan, both served in the US Supreme Court, Lord Atkin and Lord Denning, were both members at once of the House of Lords, and in Denning's case, later moved from the House of Lords to become Master of the Rolls and President of the English Court of Appeal from 1962. I've chosen these judges because they are undoubtedly favourites of mine. They're great judges, and they display great judicial qualities. Each of them have the quality of great legal writing. They show judicial fidelity to the law, judicial courage, and judicial creativity. And I wouldn't like it to be thought by picking one over than the other that these judges didn't all have these four qualities. But what I'm going to do in the time available is to select one of these qualities for each of the judges and speak to it a little bit via the slideshow. As well, and this I suppose is a purely personal, almost eccentric contribution of mine, I'd like to show in my own, I suppose, modest, I hope, way, how these judges have influenced my own judicial writing and my judicial philosophy, if such a term can be used. And in one or two instances, I'm going to refer to some of my own judgments to see how I have endeavoured to imitate the great masters. So I'm going to start with Oliver Wendell Holmes, who was born in 1841 and died in 1935, and was a judge of the US Supreme Court between 1902 and until he ultimately retired in his early 90s in 1933. And just forgive me while I start the slideshow. And the topic I've chosen for Holmes is that of Elegantia juris, the legal phrase, or the Latin phrase for elegant legal writing. Holmes was certainly an elegant legal writer and in many ways the greatest judicial philosopher the common law world has ever known. He was not, in the words of another great judge who wrote about him, Richard Posner, perfect, only great. And undoubtedly his judicial legacy has been marred by his very unfortunate and indeed in some respects quite disturbing judgment in Buck and Bell in 1926, where he upheld the compulsory sterilisation of a young lady on the basis that she was thought to have been cognitively impaired. And the language of that judgment, as I say, is most unfortunate and indeed disturbing. But if one pass over that, Holmes' contribution to the law, to the common law and to legal writing generally is inestimable, and he is certainly one of the great legal figures of the 20th century without any question. But part of Holmes' appeal is not just simply the fact that he was a great judge and a great legal writer, but also the fact that he lived in many ways a great life and had many great friends who themselves were highly accomplished. So he has undoubtedly a charm and a mystique, maybe coming from his patrician background, his Civil War experience, his great legal writings, his correspondence with some of the great men and women of the day. Um, all of that has helped to contribute to Holmes's particular mystique. Um, Holmes, incidentally, has great connections with Ireland, but that's perhaps the subject of another day's lecture. But where I'm going to start is not with his elevation to the US Supreme Court in December 1902, but rather in uh, on the 12th of July, 1864, towards the end of the American Civil War, although I think for those who were there on the 12th of July, 1864, it didn't quite seem that way. What had happened was that by mid 1864, the Union forces had surrounded the Confederate capital in Richmond, in Virginia, and were laying siege to it. But under the generalship of Jubal Early, the Confederates sent up a detachment which went south of Richmond, across Virginia, up the Shenandoah Valley, and into Maryland, and then did an abrupt turn to the right, so that within no time at all, they were literally outside Washington, D.C. This came as a huge surprise, obviously, to the Union forces. Reinforcements had to be sent very quickly at short notice to stop this Confederate detachment taking over Washington. And so the 6th Massachusetts Corps were sent up by General Grant up the Potomac into DC, and they arrived literally in the nick of time on the Sunday, the 10th of July, and were immediately sent out to fight the Confederate detachment in about place about maybe 10 kilometers north of the modern day Pennsylvania Avenue in a place called Fort Stevens. And this itself was remarkable because the second in command for the Confederates was one John Breckinridge, who had come second to Lincoln in the 1860 presidential election. He happened to be Mary Lincoln's first cousin, and the Lincolns went out and to see the fighting at Fort Stevens. And this is the subject of my, in a sense, the first slide, is a plaque at Fort Stevens, which shows events of the 12th of July, 1864, where legend has it, at least, and there may be, I think, a good deal to be said for this, that Oliver Wendell Holmes was a captain in the 6th Massachusetts Corps, and he was standing looking down at the battle with Lincoln when the Confederate sharpshooters sort of got their aim and fired a volley of shots, at which point Holmes is said to have pushed Lincoln down to the floor and shouted, "Get down, you damn fool." And this event is marked by a plaque which shows Lincoln under fire at Fort Stevens on the 12th of July, 1864. In Gore Vidal's great novel entitled Lincoln, which is a great an introduction, even though it's a novel, a great an introduction to the American Civil War as you're likely to find. He has it that Lincoln inquires of Holmes's name. Holmes tells him where he comes from, and of course, Holmes's father was a very famous Oliver Wendell Holmes Sr. Was a very famous both medical consultant who and a poet and a writer, and indeed as a medical consultant. He is credited being one of the first, I think, along with Semmelweis in Vienna, to urge the importance of washing of hands as a means of spreading infection. That's something that we're learning to this day. And he was also a writer. And anyway, in Vidal's novel, Lincoln has a few words with Holmes where Lincoln recites one of his father's poems. So that's and in the end, the Confederates were defeated. Atlanta fell to Sherman a month later. The march to the sea took place, and the rest is history, and the Civil War came to an end. But that was certainly an experience which stayed with Holmes and influences a lot of his thinking about the need for legal realism, and it was scarred by the experience of war. And indeed, Holmes showed conspicuous valor in that he was wounded 3 times. But anyway, I digress slightly, and let's move on. Holmes had a wonderful writing style, which I think has never been, almost never been equaled. And there are many famous quotations from Holmes: fire in a crowded theatre, clear and pressing danger, and so forth. And his contribution to American law is quite profound. He certainly re-envisaged how the American system of civil procedure should be organized by saying, in effect, there was no such thing as a federal common law. And in terms of constitutional law, he posed this idea of substantive due process and the idea that the 14th Amendment guaranteed property rights to the point whereby the state had no role, or many pieces of social legislation abridging or curtailing property rights were being found unconstitutional by a majority. Holmes, in his famous dissent in Lochner, New York, in 1905, opposed that, and ultimately to be vindicated by the US Supreme Court in 1937 in a case called Atlanta Hotel and Parish. But his other great contribution was in terms of free speech. And up to many of his dissents and judgments from the 1910s, 1920s, the First Amendment was really a thing writ on water, and was no more than reflecting, I suppose, a general idea of the common law, that you had a freedom of speech, but it could readily be curtailed by both judicial decision and legislation. And Holmes, and we're going to come to one of his famous cases in this area in a moment, was the judge who really, more than anybody else, turned the ship around as far as the First Amendment was concerned. And it was only after his death that many of his dissents became accepted. But he was hugely influential in terms of thinking about the First Amendment, and indeed, by extension, the right to free speech is guaranteed by Article 10 of the European Convention of Human Rights. But in terms of his, if like, Elegantia juris, one of my favorites is a little address he gave while presiding at a memorial service in a Massachusetts courtroom, because Holmes had served as a judge on the Massachusetts Supreme Judicial Court between 1882 until his appointment to the Supreme Court in 1902. And anyway, presiding at a memorial service for 2 fairly obscure lawyers, he said the following. And I've got part of the quotation in the slide, and I'll give you the full version now. He said, "Brethren, we pass from the abyss I knew not whence, into the abyss I knew not whither. And as each of us in his own turn leaves the light, someone who loved him utters a cry, and then the great silence prevails once more. The churches wisely have prepared for those supreme events, which are common to us uh, and all liturgies which deal with the universal in universal terms. There is no such service at our command. Neither have we the funeral march and the fire of guns with which the army commits its dead soldiers to the grave. And Holmes has certainly seen a lot of that in the Civil War. And he concluded, and here's the final lines: "We are here, a few men in a room, unhelped, simply stopping for a moment to look at the greatest of all facts in the face, to honour the dead, and then, like soldiers, to go back to the front and fight until we follow our brother." And you can see that some of the military language and bearing has lived with Holmes all his life. And the Civil War, I think, perhaps more than anything else, was the thing that formed his general view of life. But now let's, and you'll see this in the next judgment that we're going to speak about in a moment. The next slide. And this is one of my favourite judgments, and it's Holmes towards the very end of his life in a case called the United States and Rosika Schwimmer. Rosika Schwimmer, you can see here on the right-hand side, was a Hungarian pacifist of a Quaker background who had come to the United States, preached against war, and had declared that it was the duty of mankind to unite in what she called universal leagues. Um, um, Even though she had a Quaker background, she was an atheist and had so declared in her application for citizenship. But among her many other fine qualities was that she was perfectly honest in answering the questionnaire for citizenship. And among the questions that she was asked in the questionnaire for citizenship was, would she be prepared to take up arms to defend the United States? Now, given that she was in her mid-50s and at a time when females were not allowed to volunteer for combat duty, even if they wanted to, this was a slightly hypothetical question. But Schwimmer had no difficulty in giving a totally honest reply and declared that she would not. Because she considered that war was contrary to her deeply held Pacific attitudes. Now, case went to the U.S. Supreme Court, and in the majority judgment is given by Pierce Butler, a totally unmemorable judge of, as the name might imply, of Irish American extraction, who upheld this refusal of citizenship. But Holmes gave one of his great dissents, and Holmes essentially converted this case from a citizenship case into a free speech case by saying that her espousal of non-violence was an expression of opinion which ought to be protected by the First Amendment. And this was really one of Holmes's swan songs on the First Amendment, but he had given a series of judgments, which I can only commend to you if you're interested. Debs, Gitlow, Schenck. Schenck is the famous one of no protection of free speech would go so far as to say was protection of fire in a crowded theatre. But wonderful judgments which, really for the first time gave real flesh to the idea of the First Amendment. But let's just take a look at this passage from Holmes. And again, I'm going to just quote from something that Holmes had said in this judgment, where he had, among other things, talked about war, and that he said he didn't agree with her that the destiny of mankind was for peaceful leagues. And again, there was allusions to war, but those who had experienced war viewed it with such horror that this would be the last thing they would ever want. But then he concluded, he said, some of her answers might excite popular prejudice. And this was, I think, a reference to the fact that she declared herself to be an atheist, which Holmes was as well. Um, uh, but he said, but if there's any principle of the Constitution that more imperatively calls for attachment than any other, it is the principle of free thought. Not free thought for those who agree with us, but freedom for the thought which we hate. I think that we should adhere to that principle with regard to admission into as well as to life within this country. And recurring to the opinion that bars is applicants' way, I would suggest that the Quakers have done their share to make the country what it is, that many citizens agree with the applicants' belief, and that I had not supposed hitherto that we regretted our inability to expel them because they believed more than some of us do in the teachings of the Sermon on the Mount. And it's a really brilliant piece of legal writing by somebody who was in his late 80s. And that is such an important idea, the idea of free thought, not free thought for those who agree with us, but the freedom for the thought which we hate. And I would suggest that it's very easy to speak about free speech for those with which we agree. We have no difficulty with that, or where it's convenient to have free speech. But it's much more difficult to protect free speech for those who espouse views that are contrary to deeply held views of any given society. And that's one of the real problems in terms of the protection of free speech in a meaningful way in a modern society. But these views have been terribly influential. They have formed the backbone of the US Supreme Court's First Amendment jurisprudence. But also, it has crossed the Atlantic because really, if you look at the Sunday Times in the UK, the first real free speech decision of the Court of Human Rights in 1979, you'll see that these views, the right to be free speech means essentially not just simply the thought with which we agree, but that but views that we find disturbing and even silly are protected in principle by Article 10. And Holmes clearly had a huge influence, not only on his own court, but on other international courts. You find him quoted, for example, by the German Constitutional Court in a decision in 1958, the Luth case, which again was the really great free speech case. It started for the German Constitutional Court. And as I say, in Sunday Times and all the subsequent case law on Article 10, this passage, perhaps more than any other passage, has been the one that has so influenced the development of the law. And I did promise you a little bit of myself, where I endeavoured to express some of these views, and you can see how influenced I have been as well. This is a case called DPP and Independent Newspapers. The question concerned the publication of the so-called Anglo tapes in 2014 at a time when there was trials, then distant, they were 2 or 3 years away, of persons mentioned either directly or indirectly in those tapes. In 2000, those trials took place, I think, in 2016, 2017 from memory. But the question was whether the independent newspapers were guilty of contempt of court by publishing the tapes. A majority of the court held that they were, and this is a little bit from my dissent, where I said, admittedly, we have not, I think, the same respect for the constitutional protection of free speech, which has been one of the great glories of the US constitutional tradition since the days of Holmes and Brandeis. So you can see I'm smitten. But I went on to say free speech is the lifeblood of democracy and the democratic rule of law-based state envisaged by Article 5 of the Constitution. The right to fair trial must be protected. We can't live in an antiseptic and sterile society where robust comment on public affairs is treated like a kind of hostile germ against which the most elaborate antibacterial precautions must be taken. So, look, I confess, I've been smitten by Holmes's grandeur and style and elegance, and his protection, his dedication to the protection of free speech, among other things, has resonated hugely with me. And he obviously is one of my most favourite judges. The next one is John Harlan II. He came from a patrician background, appointed by Eisenhower to the U.S. Supreme Court in 1956, and I think that he is the greatest judge on the U.S. Supreme Court since the Second World War. I know that there's others who admire, in particular, Brennan and Marshall and Warren and Douglas, and they're all great judges in their own way. But what I particularly admire Harlan is for his style, his elegance, his craftsmanship, and his fidelity to the legal method, and in particular his very sincere commitment to what might be termed neutral judging. And by the idea of judicial neutrality is that it is the legal principle, you identify the legal principle, and that brings you to the conclusion, rather than perhaps the other way around and saying, try to identify who are the good guys and who are the bad guys and try to make sure that the good guys win. This is much more the idea of identifying a neutral legal principle and applying it to the facts of the case. And many examples could be given from Harlan of this, but I'm just going to choose two. And the first is a case called Banco Nacional de Cuba and Sabatino from 1964. And just a word by way of context about this case. This was just 3 years after the Bay of Pigs invasion. It was at the height of the Cold War. The Cuban Missile Crisis had been diffused in October 1962. And but of course, as we know, Castro had come to power in December 1959, and in the course of it, the course of 3 or 4 or 5 years, he had ultimately sanctioned the nationalization of assets of U.S. companies without compensation, as it were, by way of retaliation for sanctions imposed by the U.S. on Cuba. And the Sabatino case forms the background to that. Essentially, what happened was that a consignment of sugar was ordered by the Cuban government from a U.S. brokerage house, Farr Whitlock. They had a representative in the United States called Sabatino, and when the consignee of the sugar paid for the sugar, Sabatino handed over the money to Farr Whitlock in payment. Now, the Cuban National Bank said that Sabatino had no authority to do this because under Cuban law, under a decree passed by the Cuban regime, the sugar actually belonged to Cuba because they had, as it were, appropriated or expropriated the asset of Farr Whitlock, the U.S. brokerage firm, and declared that this belonged to the people of Cuba, and of course that there would be no payment to Farr Whitlock for their efforts. So the issue that arose for the U.S. Supreme Court really was a stark one. Firstly, could the Cuban National Bank sue in U.S. federal court? Answer given to that was yes. But the second one was this: did the conventional principle of public international law, namely that of act of state, apply in this context? Now, act of state envisages that the courts of one country will not pronounce on the validity of legislative or other measures taken by the sovereign state of another country. There are exceptions to this. I mean, it arose obviously after the Second World War in terms of, to take an obvious example, say odious decisions of a particular sovereign state. So would the Nuremberg laws of the Nazi regime of Nazi Germany be recognized when it deprived Jews of citizenship? And there's case law on that. So there is an idea of an exception to the act of state doctrine that in public international law, where the decision taken by the foreign state contains principles that are so odious or so manifestly repugnant that they shouldn't be recognized. So that the host state, so to speak, the courts of the host state could go behind, so to speak, the decision of the act of state of the other country. And that was the issue. That was the argument essentially in Sabatino. It was more or less conceded that on the conventional act of state doctrine, that the U.S. courts couldn't look behind what the Cuban sovereign had decreed. And the Cuban sovereign in this instance had decreed that the sugar should be expropriated without compensation. But the argument was, well, look, this is a decision of a communist regime that has expropriated U.S. assets without compensation, and we should look behind that by way of exception to the act of state doctrine. But 8-1, in a judgment led by Harlan, the US Supreme Court refused to do that. They said that, and it's a real masterclass in international law from Harlan, in that he went on to say that, and I'm going to quote here, the disagreement as to relevant international law standards reflects an even more basic divergence between the national interests of capital importing and capital exporting countries and between the social ideologies of those countries that favour state control of a considerable portion of the means of production and those that adhere to a free enterprise system. It is difficult to imagine the courts of this country embarking on an adjudication in an area which touches more sensitively the practical and ideological goals of the various members of the community of nations. So here, Harlan was saying, look, act of state is designed to reflect the sovereignties of the various different countries. The communists are entitled to have that sovereignty as well, even if we don't like them. And it isn't appropriate for us, if you like, a capitalist country, to pronounce by way of exception to the act of state doctrine and say that we won't recognize the decrees of the Cuban regime. Now, when you think of it, this, as I say, was the height of the Cold War, 2 years after the Cuban Missile Crisis, 3 years after the Bay of Pigs. And this was somebody appointed by, this was a solid Republican of a patrician background, appointed by a Republican president. And there's no Congress is absolutely up in arms at the idea that the US Supreme Court should take that view, that in effect that decrees of the communist regime of Castro were going to be recognized. But Harlan stood firm. He clearly had no sympathy for Castro or for the Castro regime, but he applied. The critical point is that he didn't reduce it to good guys and bad guys. He applied the legal principle recognized by public international law in a neutral way, even though it resulted in a decision that wasn't going to be terribly popular. And as an aside, one feature about the Sabatino case that's worth mentioning is this. So far as I can see, there have been only 2 instances, certainly post the Second World War, where a decision of our courts has been referred to by the US Supreme Court. One is in a case called Ray Galt, where from 1967, where I suppose there's a slight homage to Mr. Justice Brian Walsh. Mr. Justice Brennan refers to the Galt, refers to the state in Galt, refers to the state Sheeran and Kennedy from 1966. That was Galt was also a case about criminal justice for juveniles. So there's and the mention of Brennan, I suppose by way of friendship, mentions in a footnote the state cheering in Kennedy, the decision of Walsh. But in Sabatino, um, the Harlan um, refers to what he decides of a decision of the Era High Court of Justice, and he gives great attention to the decision of Mr. Justice Kingsmill Moore in Peter Buchanan and McVeigh case from 1955, and I'll just quote what he says: in discussing the rule against enforcement of foreign penal and revenue laws, the Era High Court of Justice and Peter Buchanan and McVeigh, 1955, emphasised that its justification was in large degree the desire to avoid embarrassing another state by scrutinising its penal and revenue laws. Although that rule presumes invalidity in the forum, whereas the act of state principle presumes the contrary, the doctrines have a common rationale, a rationale that negates the wisdom of discarding the act of state rule when the plaintiff is a state which is not seeking enforcement of a public act. So that's one of the few instances, I think perhaps the only real instance, where a decision of our court post 1922 has been referred to in any detail in a decision of the US Supreme Court. But that's an aside. The real feature of Sabatino is that it's a masterclass in public international law. It's a masterclass in fidelity to the legal method by applying this principle neutrally, even though it results in a decision which you know is going to cause uproar and unhappiness on the part of your own Congress. Now, the second example that I'd give is a case called Orozco in Texas from 1969, where it concerned the application of the famous Miranda rule. And this is the Miranda warning which suspects were required to be given for Fifth Amendment self-incrimination purposes by the US Supreme Court. There was a dissent in Miranda, and Harlan was one of the dissenters. But the point I'm going to make here is this, is that in Orozco, the question arises as to whether or not Miranda should be applied. And this is what Harlan had to say. Should he apply Miranda even though he had dissented? He said, the passage of time has not made the Miranda case any more palatable to me than when it was when the case was decided. Yet, despite my strong inclination to join the dissent of my brother White, I can find no acceptable avenue of escape from Miranda in judging this case, particularly in light of another recent decision. And he said, therefore, and purely out of respect for stare decisis, I reluctantly feel compelled to acquiesce in today's decision of the court, at the same time observing that the constitutional condemnation of this perfectly understandable, sensible, proper, and indeed commendable piece of police work highlights the unsoundness of Miranda. And again, I think that's something that is appropriate for all of us to learn and to apply. That we might have strong views as judges, but that we should generally, not always, defer to the majority view. And in a sense, once something has become the accepted law, that we should apply it, even though it conflicts with our own deeply held views and beliefs. And I'm going to give, again, in my own, I hope, modest way, an example of where this thinking of Harlan resonated with me. This is in a case called ACC Loan Management in Connolly in 1977, 2017. It was a case as far removed from Miranda as you can envisage. It was rather a separate question of the application of the Ettridge principles delivered by the House of Lords in 1994. Did they mean that if a family member was going to act as a guarantor for another family member, that they should normally be independently legally advised? And I had thought that they should, and I had said the first part of my judgment, I said, if there's no modern willingness to refashion and adapt these principles to modern conditions in the case of vulnerable sureties, it may simply be that we, the judges, who are required to tend to the gardens of equity by ensuring that their verdure remains fresh, vibrant, and relevant to the modern world, have allowed an ancient path of escape from the gravel paths of the common law to become disused and overgrown. So flowery language for me, but the question was, uh, what, what should I do? And the reason was this, is that I had first dissented on this question in a case called De Kretzer at the start of December 2016, where my two colleagues, Mr. Justice Birmingham and Mr. Justice Peart, had said that there was no arguable case that the Ettridge rule had this effect. And then a few weeks later, a differently composed panel of the Court of Appeal, in a case called Curran, Miss Justice Irvine had given a judgment saying that there was no such duty as well, so affirming the majority decision in De Kretzer. And then in April 2017, at a different panel, presided over by Miss Justice Finlay Gagan, was required to consider this. And I was sitting on that panel, and I had to. The majority view was that the majority in De Kretzer was correct, that Judge Irvine's judgment in Curran was correct, and they were going to follow that. And then I had to ask myself, what should I do? And I said, and again, trying to being influenced very much by Harlan, I said, while I respectfully adhere to the views which I've expressed on this topic on the duty of banks regarding the giving of guarantees by potentially vulnerable sureties in both my dissent in De Kretzer and elsewhere in this judgment, it's important in a collegiate court such as the Court of Appeal that an individual member should ultimately submit to the settled views of the majority of that court as reflected by stare decisis. As I consider that the issue has now been effectively determined by the majority decision in De Kretzer and the unanimous decision in Curran, it is accordingly therefore simply for reasons of stare decisis that I agree with the decision of Miss Justice Finlay Gagan that the defendant hasn't raised an arguable case. So again, it was very much influenced by the Harlan thinking that yes, you state your position, but if the rule has become a settled one, and that is the majority view on a collegiate court, then it is your duty to follow it, even though you personally disagree. So Harlan is fidelity to the legal method. Now I'm going to come to Lord Atkin, judicial courage. Atkin, of course, is best known for his famous judgment in Donoghue and Stevenson, but my favourite judgment is his judgment, his dissent for the House of Lords in a case called Liversidge and Anderson in November 1941. Now, this is John Anderson, the Home Secretary, who made the order detaining Liversidge under Regulation 18B for alleged enemy association. So Liversidge was interned. He was in fact an RAF officer who was interned during the Second World War by Sir John Anderson. He was represented by British Labour MP in QC called D.N. Pritt. And Pritt himself, Dennis Pritt, was quite a remarkable fellow in his own way. He had, among other things, defended Ho Chi Minh in an extradition case in Hong Kong in 1935. He'd been, to give you a sense, even though he went to school in Winchester College and the University of London, to give you a sense as to his leanings at this stage, he had been invited to attend one of the Stalin show trials in 1936 in Moscow, which he did, and pronounced it generally to be fair. I think, a view that caused not a few eyebrows to be raised. But ultimately, I think the last straw for the British Labour Party was when, in February 1940, he gave a speech applauding Stalin's invasion of Finland during the Winter War. So by this stage, Pritt had been expelled from the British Labour Party. He was in a list published after his death by George Orwell. Orwell named Pritt as the leading fellow traveller in the UK, and I don't think that you really needed to consult Orwell's list to get a sense of this. But he was nonetheless a great MP and a great QC, and he represented Liversidge in this. Now, again, a word by way of context, because this was judgment was given in November 1941, at a time when, true, the Battle of Britain had been won, but the war wasn't necessarily going terribly well for the UK, and Pearl Harbor was 6 weeks away, so the US still hadn't entered the war. The Liversidge was an unusual individual. He was the son of a rabbi and was of Jewish background. He had got involved with a number of shady characters, but I don't think ever actually had done anything terribly wrong. Apart from at one stage a false passport. Having a false passport, but he changed his name from Perlsveig in 1936 to Liversidge, which was the name of his sister-in-law, and he was a businessman. I think, really, apart from the fact that he had a false Canadian passport and had used a false name on one or two occasions, and had associated with some people who themselves were perhaps a bit shady. There was nothing, I think, particularly dangerous about Liversidge. And he had, in fact, signed up for the war effort and was an officer in the RAF when he was interned. Now, he was interned, it seems, on the basis that, rather perversely, his father was a rabbi, which I would have thought in Britain of 1940-41 would have been a plus in terms of fighting the Germans. And the second thing was that it was alleged that some rather odious anti-Semitic comments were made in a secret memorandum, which was in the possession of MI5, in which was alleged that a number of Jewish officers were seeking to effectively looking for bribes to release particular prisoners. This was a charge which Liversidge was later ultimately utterly to deny, and there doesn't seem to be any basis at all for it. And it seems to have been the kind of rather the product of rather febrile imagination against Liversidge, sometimes as happens in the course of a war or other events of this kind. And while the tribunal, which was presided over by Norman Burkitt, later Mr. Justice Burkitt, who was later to become one of the British judges serving on the Nuremberg trial, at that stage QC or KC, Burkitt, I think, was concerned that the case against Liversidge was not very strong, but the senior officers in the RAF had said that Liversidge was too dangerous to be released, and given that the Battle of Britain was just over and so on, the internment tribunal hearing this appeal really felt it had no option but to affirm the decision of the Home Secretary to intern Liversidge. Liversidge wasn't deterred by this and commenced proceedings against the Home Secretary Anderson for a false imprisonment. And the plea in the defence was that the detention was justified under Regulation 18B of the internment regulations. Regulation 18B allowed you to be detained if you had what were described as hostile associations. And the only hostile associations that were pleaded in the defence was as follows. The said Liversidge was associated from time to time with Germans and with those associated with the German Secret Service. Again, anybody who knows anything about Liversidge would regard that as absolutely absurd. So not surprisingly, Liversidge sought particulars of this alleged hostile association. And the case really turned. So rarely has a notice for particulars assumed such a great constitutional importance, but this did. Because it went to the heart of what Regulation 18b was all about. The majority view delivered by Lord Malm, who had been Chamberlain's Lord Chancellor between 1937 and 1939, so had been Lord Chancellor at the time of the Munich crisis. He was presiding. He wasn't presiding, but he delivered the majority judgment in which effectively the House of Lords said, well, the Regulation 18b means that the word hostile association essentially enables the Home Secretary, if he believes that the person has hostile associations, to detain him, not that he actually has hostile associations. And the whole Liversidge and Anderson really turned on this. But we now come to the dissent. Lord Atkin did preside at the hearing and gave the following very famous dissent. He said, in England, amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty, which on recent authority we are now fighting, that the judges are no respecters of persons, and stand between the subject and any attempted encroachments on his liberty by the executive, alert to see that any coercive action is justified in law. And next come to a passage which I just invite you to pay a little bit of particular attention because it's the subject of the next slide. But just let's focus on this for the moment. He said, I know of only one authority which might justify the suggested method of construction. When I use a word, Humpty Dumpty said in a rather scornful tone, it means just what I choose it to mean, neither more nor less. The question is, said Alice, whether you can make the words mean so many different things. The question is, said Humpty Dumpty, which is to be master? That's all. This is a quotation from Lewis Carroll's Through the Looking Glass. Yet after all this long discussion, the question is whether the words if a man has can mean if a man thinks he has. I am of opinion that they cannot, and the case should be decided accordingly. Now, that dissent, delivered as it was in November 1941, in itself showed immense judicial courage in standing for the rule of law at a time of great difficulty for the United Kingdom and in some respects at a low point during the Second World War. But that wasn't the only difficulties that Atkin had to face, because a few days before the judgment was delivered, Atkin had received the following rather unwelcome letter from the then Lord Chancellor, Lord Simon. Now, just to put all of this in context, Simon had been Chamberlain's foreign secretary in the up to May 1940, and he had been foreign secretary during the Munich crisis, and following the reshuffle and reorganization of the government on Churchill coming to power in May 1940, Simon was made Lord Chancellor. Lord Chancellor was then head of the judiciary, essentially president of the Judicial Committee of the House of Lords, but he was also, for good measure, the Speaker of the House of the other part of the House of Lords, and was a member of the government. So he was a sort of a walking challenge to the separation of powers, in that he was simultaneously a member of both the executive, the judicial branch, and the legislative branch. But Simon had asked the chief clerk of the Law Lords for a copy in advance of the judgments in Liversidge. And the letter to Atkin is dated the 31st of October 1941, so a few days before the judgment was due to be delivered. And Simon said to Atkin that he had seen the judgments and he had read them very quickly, but he went on to say, he said, "My eye catches your very amusing citation from Lewis Carroll. Do you really, on final reflection, think this is necessary? I feel that it may be regarded as wounding to your colleagues who take the view you satirize, and I feel sure you would not willingly seek to hold them up to ridicule. I'm all in favour of enlivening judgments with literary allusion, but I would venture, greatly daring I know, to ask you whether the paragraph should be retained. Of course, it is entirely a matter for you. I, at any rate, feel that neither the dignity of the House, nor the collaboration of colleagues, nor the force of your reasoning would suffer from the omission." So this was essentially a plea by Simon to Atkin to get rid of that particular Humpty Dumpty quotation in his dissenting judgment. And this is pressure which Atkin resisted. And the passage is in the judgment. But after that, Atkin had to endure a lot because he was essentially sent to Coventry by his colleagues. They never spoke to him again, and in some ways, Atkin never recovered from that ordeal, and he died a few days after D-Day in June 1944. And it would have been so easy, really, to roll over and to say, where do I sign up to? The majority judgment. But Atkin showed real judicial courage in standing up for his principles, standing up for the rule of law, and giving a judgment which has echoes in favour of personal liberty to this day. And as I said, it's one of the greatest examples of judicial courage you can think of. Now, our final choice is that of Lord Denning, who I've titled Legal Genius and Creative Destruction. And the creative destruction bit, I suppose, is been influenced by the great Austrian-US economist Schumpeter, who believed that the great advantage of capitalism was creative destruction, that you, in a sense, had to move with the times, for old-fashioned industries to go by the wayside, to be replaced by new developments, technological innovation, which would in turn be replaced by others. And so this idea of creative destruction being at the heart of the capitalist system. And I can't but help think that that's true of Denning too. He was appointed a High Court judge in 1945, was rapidly promoted to the Court of Appeal, served in the Court of Appeal from 1951 until 1957 when he was promoted to the House of Lords, and then following some unhappiness with his colleagues, he decided that he would have become Master of the Rolls and President of the Court of Appeal in 1962. He was appointed to that position by Viscount Kilmore, and he remained President of the Court of Appeal and Master of the Rolls until his retirement in 1982. But there's no doubt Denning was a genius and had an incredible overview of every aspect of the common law, and was dissatisfied and unhappy with the kind of formalism and stultified way in which of the common law which he founded, and he was determined to make the case for change. And one of the cases that I think is his greatest, and perhaps one of the greatest dissents in the entire history of the common law, is that of his dissent in Candler and Crane Christmas in 1951. And that was the question. It was essentially the issue of Headley Byrne, before Headley Byrne was decided in 1963-64, whether or not somebody could owe a duty of care in respect of negligent misstatement. And this was in the context of accounts that had been negligently prepared by a particular accountant that were shown to Candler before he invested in Crane Christmas Company, and then ultimately the Crane Christmas Company went insolvent, and the company which he invested went insolvent, and Candler sued Crane Christmas, who were the accountants who had negligently prepared the accounts. Now, the majority judgment given by Lord Justice Asquith, but Denning's dissent is famous, and it's particularly famous for these words. He said, if you read Ashby and White, Pawsley and Freeman, and Donoghue and Stevenson, one finds that in each of them the judges were divided in opinion. On the one side, there were the timorous souls who were fearful of allowing a new cause of action. On the other side, there were the bold spirits who were ready to allow it if justice so prevailed. It was fortunate for the common law that the progressive view prevailed. And Asquith's response, son of a famous prime minister, Asquith, said, well, if that makes me one of the timorous souls, so be it. But this was Denning at his very, very best. And the Denning of the late 40s and the 50s is one of the greatest, some of the greatest judgments the common law has ever seen. And in many respects, Holmes and Denning are similar. They're in a sense, they are for their respective jurisdictions, they are the legal icons. Denning, in many ways, was a better technical lawyer than Holmes. They were both great writers, but the one other difference between both also have terrible blots in their copybook. We've mentioned Buck and Bell for Holmes. We only have to think of the Birmingham 6 decision for Denning. But there is one difference, is that Denning unfortunately deteriorated, I think, in terms of style from the 1960s onwards. And I think that unfortunately he became a victim of his own success, and there was almost a cult of personality about him, sometimes in the British tabloid newspapers, which I don't think necessarily suited the administration of justice. And there is a book review which I could only urge on you by Mr. Justice Keane, then a judge of the High Court, later Chief Justice, in the 1984 Irish Jurist of Denning's The Discipline of the Law, one of the books that he wrote towards the end of his life. But Justice Keane had the following words to say about Denning. He said, before he came to preside in the Court of Appeal in 1962, he had given ample proof of his outstanding judicial qualities: patience, courtesy, an open and inquiring mind, unrivaled legal erudition, and an immense capacity for work. It was during his career as Master of the Rolls, however, that the Denning beloved of the media began to appear. The judgments composed in staccato prose, the uninhibited voicing of prejudices usually discreetly veiled, the cavalier disregard of inconvenient precedent, and the readiness to become embroiled in open conflict with the House of Lords. And in a sense, those words express far more eloquently than anything I could possibly say as to the downside of Denning, and how even though in many ways he was the greatest judge in the common law world throughout the 20th century, maybe to some degree his legacy has been tainted post 1962. And Mr. Justice Keane's words, as I say, sum it up what these difficulties are. And I'm just going to give you one or two examples of how I think the Denning style deteriorated into this staccato style prose, sometimes with no verbs and sentences and so on, sometimes almost as if it was written in the style of a tabloid newspaper. And it's a far cry in some respects from the elegance of Denning of the 1950s. I'm just going to give two examples. One is a case called Tanner and Tanner, one of these judgments about constructive trusts between unmarried couples and so on. And speaking of the father of the children, he had said, I think he had a legal duty towards them, not only towards the babies, full stop, but also towards their mother. Um, um, and then in another case, I think speaking of really a personal tragedy in rather, it might be thought offhand terms, he said, a man, this is how the judgment starts. People often talk about the famous one, Hines and Perry from 1972, it was Bluebell time in Kent. But how about this for starting a judgment? A man's head got caught in a propeller. He was decapitated and killed. And then in Allen and Jambo Holdings in 1980. I don't want to be too critical, but one might say that really language like that is somehow jarring in terms of somebody with the consummate legal writing skills that Denning had. But for all that, he was a legal genius and changed the common law forever. And this, in a sense, expresses this following passage from 1959 expresses his views. He said, "What then is the way of an iconoclast?" And he was a self-confessed iconoclast, legal iconoclast. It is the way of one who is not content to accept cherished beliefs simply because they've been long accepted. If he finds that they are not suited to the times or that they work in justice, he will see whether there is not some competing principle which can be applied to the case at hand. He will search the old cases and the writers old and new until he has found it. And Denning, of course, could do that better than anybody else because he had almost unrivaled knowledge of the case law and an incredible memory for earlier decisions, which he could capaciously reach back into his mind and, in a sense, quicker than any legal retrieval computer legal retrieval mechanism, retrieve it and use it in a way as to fashion the law along his lines. And I suppose the following quotation from a dissent of Denning, typically in Packer, typical dissent from the Court of Appeal in many ways when he was at the zenith of his powers, sums up his approach. What is the argument on the other side? Only this, that no case has been found in which it has never been done before. That argument does not appeal to me in the least. If we never do anything which has not been done before, we shall never get anywhere. The law will stand still while the rest of the world goes on, and that will be both bad for both. So that, in a sense, that quotation from Packer illustrates not only Denning's legal genius, but the idea of creative destruction and development of the legal system. And he was in a hurry to do this in a common law that had become uncreative, dull, and stultified. And that was one of Denning's many, many achievements. And so, ladies and gentlemen, we come to the point whereby I hope you have enjoyed this tour of the of four favorite judges of mine. They are all great judges. I think you will agree. Perhaps in Posner's words, Holmes not perfect, but certainly great. And we in the legal community have so much to learn from each of the four of them, and to be thankful to them for their greatness and their gifts of Elegantia, juris, fidelity to the legal method, judicial courage, and legal genius and creative destruction. Ladies and gentlemen, thank you very much.